Some of the most powerful rights in property law aren't something you'll find in a formal deed or a contract. They aren't written down, not in the way you'd expect. Instead, they're forged by history, by sheer necessity, and by promises that become, well, embedded in the land itself. Today, we're diving into these unwritten rules, implied easements. Okay, let's jump right in. Our story starts with a promise that was over 100 years old and a brand new barbed wire fence in southern Colorado. This is the very heart of a landmark case, Lobato v. Taylor, a massive conflict that pitted the descendants of the area's original settlers against a modern landowner.
And you have to understand, what was at stake here wasn't just a piece of land. It was about survival. For generations, these families depended on this huge 77,000-acre mountain tract for everything, grazing their animals, getting firewood, timber, the absolute essentials of life. So this conflict wasn't some quick dispute. We're talking about a fight that spanned over 150 years. It started with a Mexican land grant, survived the Mexican-American War, and then ended up in a modern legal battle that went on for decades. All of it centered on this one vital piece of land. So you've got to be asking yourself, how could a promise from 1863, written in Spanish, in a document that doesn't really meet any modern legal standards, how could that possibly hold up in court today? Well, the answer starts with a really basic rule of property law. Generally, the law says that any right to use someone else's land, which lawyers call an easement, it has to be in a formal, written document to be legit. And that makes sense, right? It's there to prevent fraud and to make sure that anyone buying land knows exactly what they're getting into. And this is where the law gets really creative. To stop that rule from being used as a tool for injustice, courts have developed some really powerful exceptions. You can think of them like legal safety valves that are built for fairness. So it turns out courts recognize at least 4 ways an easement can be created by implication without that perfect written document. And in the Lobato case, the court actually pulled out and used 3 of them to fix things for the settlers. All right, so how did the court actually solve this puzzle? The Colorado Supreme Court basically opened up a powerful toolkit of legal doctrines to unravel the mystery of the settlers' long-held rights. First up, the court found what's called an easement by estoppel. Now, don't let the legal term throw you off. This idea is really all about fairness and reliance. It basically stops a landowner from yanking away permission after someone has reasonably relied on it. The logic here was pretty clear. Carlos Bobian invited people to settle his land, and he promised them access to all these common resources. The settlers took him at his word. They relied on that promise to survive, moving their families and building entire communities there. Taking those rights away a century later, that would be a massive injustice. And wow, this quote from the court just nails it, doesn't it? The settlers' reliance wasn't some minor detail. It was the very reason Bobian's own title to the land was confirmed in the first place. They held up their end of the bargain. Okay, next up, the court found an easement implied from prior use. This rule looks at how a piece of land was being used before it got divided up and sold off. The whole idea is to protect the reasonable expectation that an existing, important use is going to continue. And when you look at the legal test for this, it's pretty amazing how perfectly the facts of this case just tick every single box. Bobian owned the whole thing? Check. The common lands were used before he deeded out the individual farms? Check. The use wasn't temporary? Yeah, 100 years is pretty permanent. And was it necessary? Absolutely. It was crucial for their survival. And finally, the court found a prescriptive easement. Now, this one is a little bit like adverse possession, squatters' rights, where someone can gain ownership by openly using land for a long time. This is its cousin, but it applies to using the land, not owning it. You're basically acquiring a legal right through long-term, open use. The implication here is just so powerful. It means that even if the original promise was just seen as permission, the settlers' actions over more than a century transformed it. By using that land openly, continuously, and acting like they had a right to it for over 100 years, they forged an independent legal right that the new owner, Jack Taylor, simply could not take away. Look, the Lobato case is this incredible, dramatic piece of history, but the principles behind it aren't just stuck in the past. These unwritten rules pop up all the time in totally modern situations, especially when a piece of property ends up landlocked. So just imagine this scenario. You've got a piece of land that is completely surrounded by other private property. You have no way to get to a public road. It raises a huge question.
How can you even use your land if you can't legally get to it? Well, the law has a direct answer for this. And that answer is an easement by necessity. The key here is that the property has to become landlocked at the exact moment it's divided from a larger piece of land. The law just sort of presumes that nobody would intend to create a totally useless, inaccessible piece of property.
Now, this is a really fascinating concept. A legal right to access can literally attach to the land when it's created, just lie there dormant for generations when it's not needed, and then suddenly be awakened the moment it becomes necessary. It's wild. And this brings up a really important distinction. For an easement by necessity, the standard is super high. It's strict. You have to be completely, totally cut off from a public road. But for an easement from prior use, like those driveways in a shopping center we saw in the Granite Properties case, the standard is more flexible. The use just needs to be reasonably necessary for the convenient enjoyment of the property. So, after going through all these different legal doctrines, you have to step back and ask, why? Why does the law go to such great lengths to create these rights that were never formally written down in the first place? I mean, why does any of this matter if you're not caught in a century-long land fight or you don't own a landlocked property? Well, it really comes down to a few core principles about what we expect the law to accomplish for us. At their heart, all of these doctrines are the law's attempt to solve a puzzle. How do you balance two competing goals? On one hand, you need clear, written rules for certainty. But on the other hand, you have the practical reality of how people actually use, rely on, and develop expectations about the land all around them. Ultimately, these cases are a great reminder that our rights and our responsibilities to each other can be shaped not just by ink on a piece of paper, but by the enduring patterns of life and necessity on the land itself. It kind of makes you wonder, right? What other unwritten rules are shaping the world around us?